Life is not as complex as we make it. The universe itself is actually very, very lenient on assisting us in being the best that we can. If it wasn't based on the level of fuckery that humans engage in, we will have been long wiped out and permanently kept that way. See, the thing is, most people make things far more complex than it ought to be. Reality is not that complex. Reality is very user friendly. Whether that reality be that which someone else has created as an issue, purposefully, deliberately, with other ulterior motives, or just the accidents of realities, not coincidences. Coincidence just means two things happening at once. Co means duplicate or together. Incident is just an occurrence. So coincidences are not accidents. We're not speaking about coincidences. We're speaking about accident here. Regardless of whether it's a deliberate thing or an accident, reality is user friendly. We are the ones that make it difficult. Because of those, we are also the ones that can create the solution. The beauty of it all is we all share a certain consciousness. As I always say, no matter what you think you are, who you think you are, how special you think you are, you share a collective consciousness with everyone else that does not look like you, that does not speak like you, that does not act like you, that does not subscribe to the same concept as you do. And by virtue of that same collective consciousness, when one man finds a solution to something, it is as though and is as similar as though everyone else has. And that is almost like a life hack that we have as a human, since we share collective consciousness. If we are the source of our own problems, we are also the source of our own solution. And since problems and issues tend to find you, no matter where you are, problems somehow manage to somehow always find you. Solution, on the other hand, you have to seek it. That's the funny thing about how this reality works. Problems always seem to come up all the time. Solution, though, you have to seek it. And it first begins with that same collective consciousness of your mind. You might stumble upon some information that might seem like an accident, but you sought that solution out some way, somehow. In some cases, the problem also. But the good part about the solution is, if one man finds it out, given that you and I share collective consciousness, it is as synonymous as you finding out also. All that is left is for that man or woman who found it out to simply introduce it to you. And it will make more sense, because that's probably one of the things you've been seeking. The subject matter of Fourth Amendment. See, this Fourth Amendment and all the other amendments are merely summary of something that exists. And within each of these summaries, each term that are used, militia, soldier, person, unreasonable, search, probable cause, each of these terms have definitions. Each of these terms have exceptions. Each of these terms have doctrines attached to them. Know that whenever you read any given right, each and every one of those rights that you are reading, listening to, or saying that you have, or saying that it's preserved, are merely a summary, meaning there are intricate details specific to the totality of circumstance. Two men can claim to have the same exact right, for instance, Fourth Amendment probable cause. But those two different men or women that claim to have the same right might deal with the exact circumstance during the exact day. One of them will be screwed over, one will not be. And if they're both screwed over, one will properly get restitution and make their lives better by virtue of either holding someone liable to change the ebbs and flow of society, or their pockets getting bigger because they truly comprehend the intricacies of what they say these rights are. When you try to gain restitution or hold anyone liable, not hold them harmless by sending in some false paperwork about some dead status somewhere that even you don't know anything about, claiming to be a secure party. I'm speaking of when you know what your substantive rights are and the details of it, and you start to get things on pen and paper. The details of this is what you will enforce, because the intricacies of this is deep. Each of these rights are a mere summary, just summarized in these papers. This is the reason why two people can exist in the same space. Two people can occupy the same space. But the reality that they both exist in, the reality that they're playing out, the reality that they attract, completely different. Two people can be in the same building, the same house, the same room, but the reality that exists within each of those power plants called people, completely different. Despite occupying the same space, but the reality they exist in, completely different. The reality, and that which delineates the difference between the reality someone lives in, regardless of what we observe with our five senses, and the reality is created, is what we know in our minds. Fill your mind with the proper information, rather than just a summary of buzzwords of things. On the note of the Fourth Amendment, the right of the people to be secured in their persons, houses, papers in effect, against unreasonable searches and seizures, shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing a place to be searched, and the person or thing to be seized. On Patreon, we went over how use of force can be determined to be reasonable or unreasonable, and that falls under the Fourth Amendment, and in some cases it can fall under the Eighth Amendment, cruel and unusual punishment, but more so under the Fourth Amendment when it comes to seizure or search, because they will use force one way or another, physically or otherwise. Then there are other doctrines like the knock and talk doctrine, but in this case let's look at the doctrine of the fruit of the poisonous tree. So many people have this prerequisite comprehension that in order for someone to be searched, there has to be a probable cause, right? But then there's this other thing whereby they say, well, probable cause don't always have to exist so long as a reasonable, articulable suspicion exists. But then the way that we will define search and seizure will be short, temporary, and restricted to outer layers, and for the strict purpose of finding weapons. And it must be as a tool of investigating a crime, even though we've yet to establish probable cause. Meaning we can create probable cause by doing the same thing to which the same probable cause is first required to be done. Hence the loophole that a lot of people don't know about. Yet they go on about their rights. If you don't know the loophole that's been set up in your rights that you say is preserved by a body of instrument, if you don't go into a field, if you don't know what the playing field and the venue and the battlefield is, and you're going in there blind without comprehending the ammunition that the other party has prepared to be used against you, that which you say you have will not favor you. And by the way, every time I use that term loophole on this page, I mean it for exactly what it's meant to be, because a loophole is meant to be a tool that's also used, just like any of these given rights are used. A loophole, an arrow slit, often also referred to as arrow loop, loophole, or loophole, and sometimes a balistraria, is a narrow vertical aperture and fortification through which an archer can launch arrows, or a crossbowman can launch bolts. In other words, this thing called loophole, in its original functional sense when it comes to architecture and the building of castles and things like that, it's a defensive mechanism that is inbuilt inside any structure. A loophole is specifically built into castles so that a long-range attack can be done from that loophole meaning it's not an error in the structure of the building. It's deliberately created there as a space for someone to shoot trajectory for the purpose of defending that castle. See this thing called rights. There are many, many loopholes in it. This United States Constitution, and most of the ones that come after the 1700s on a state level, they were merely a recreation and a remix of pre-existing ones, which are Articles of Confederation. We would often hear them say that the Articles of Confederation is not perfect, so they created and ratified the one in 1791. But here's the truth about when you hear them often. When you hear people tell you, well, the reason why the 1791 United States Constitution was created was because of the imperfection of the Articles of Confederation and Association. It's not perfect for the representatives of the United States because the Articles of Confederation and Articles of Association did not grant them any power. It literally spoke of nothing regarding power when it comes to the representatives of the United States. In other words, there were no loopholes within the Articles of Confederation and Articles of Association. Remember, a loophole is a structure deliberately created within a bigger structure so that trajectories could go through it in order to defend that structure itself. So when this United States Constitution 1791 version was created, a lot of loopholes were created into it. If you do not know these loopholes created specifically into this thing called, quote, your preserved right per the United States Constitution or the respective state constitutions, then you will get their arrow, their burning, sharp, slithering arrow come through that loophole and hit you from nowhere. You have to know your terrain and your venue. You have to know the loopholes within this castle called the United States Constitution. Then you'll be able to navigate properly and access that castle. And one of the loopholes between that is embedded into this Fourth Amendment outside of the Terry versus Ohio, aka investigatory stop or Terry stop, outside of other principles that we went over on Patreon and that we'll slightly go over here on YouTube. One of them is a doctrine called Fruit of the Poisonous Tree. Now, this loophole that's embedded into the castle of the preserved rights of the Fourth Amendment is actually a positive one for you. But if you don't know that this loophole exists, you will not be able to put it to use. Fruit of the Poisonous Tree. A doctrine, as always, doctrines are the backbones of what you say your rights are. If you say you have a right and you do not know the doctrine, you're still playing around. If you don't know the standard, the element in the test, you're still playing around. A doctrine that extends the exclusionary rule to make evidence inadmissible in court if it was derived from evidence that was illegally obtained. What is the exclusionary rule? The exclusionary rule prevents the government, meaning the people that are coming to you say, you don't have this right, we're able to abrogate on you. Meaning now there are rules that are benefiting you against those that you hate so much. But keep running away from, quote, their rules and fail to realize that these things benefit you also, and you're meant to put it to use. The exclusionary rule prevents the government from using most evidence gathered in violation of the United States Constitution. Meaning, if something was gathered against you and it incriminates you, even if you did in fact engage in that thing, but the method in which it was gathered was unconstitutional, then it can be excluded as an evidence against you. It's that simple. The fruit of the poisonous tree is an offshoot of that exclusionary rule, and that ties to the probable cause principle within the Fourth Amendment. A doctrine that extends the exclusionary rule, meaning it's an extension of the exclusionary rule to make evidence inadmissible. We always speak about the evidence rule and the law evidence here. because evidence is a backbone of any given case, and doctrines go hand in hand with how and why they work. Fruit of the poisonous tree is a doctrine that extends the exclusionary rule to make evidence inadmissible. In other words, if you can properly invoke this doctrine as part of your affirmative defense, as shown to you in Rule 8 and Rule 12, which is also the same twin that's used to basically dismiss your claim for failure to state a claim upon which relief can be granted. The fruit of the poisonous tree, again, is a doctrine that extends the exclusionary rule to make evidence inadmissible in court if it was derived from evidence that was illegally obtained. As the metaphor suggests, if the evidential tree, quote, is tainted, so is the fruit. In other words, if the source and the manner as to which that which the other parties bring into you to say, hey, you've done something wrong, you're liable, if the source of it or the manner to which it's derived is somehow wrong or unconstitutional, aka they refer to as the poisonous tree, then everything else that comes out of that for them to state a claim against you is dead, and it is a nullity. A doctrine that extends the exclusionary rule to make evidence inadmissible in court if it was derived from evidence that was illegally obtained. As the metaphor suggests, if the evidential, quote, tree is tainted, so is the fruit. The doctrine was established in 1920 by the decision Silverthorne Lumber Co. versus United States. The phrase, quote, fruit of the poisonous tree was coined by Justice Frankfurter in his 1939 opinion in Nardone versus United States. Like the exclusionary rule itself, this doctrine is subject to three important exceptions. This is regarding evidence now. And the evidence being the backbone has doctrine, standards, tests, and elements to it. And one of the doctrine, standard, test, and element to the admissibility of evidence. In the previous video, we went over the 4 stages of evidence. First being applicability, second being admissibility, third being authenticity, and the fourth being exception. And usually the last part being the exception works hand in hand with the first 3. So within evidence law, the doctrine, one of the doctrine, is the doctrine of the exclusionary rule, to which the fruit of the poisonous tree is an extension of. And that doctrine that's tied to exclusionary rule when it comes to the introduction of evidence basically says if the means or the source to which something is derived to be used against you is wrong, then that means that thing itself and everything else that comes out of it is also wrong. But just like there are 4 stages to evidence, the 4th one being exceptions, and given the fact that this is a doctrine based on evidence, of course, there's exceptions. Henceforth, like the exclusionary rule itself, this doctrine is the subject to 3 important exceptions. When something or someone is subject to another thing, that means they are at the peril, it's encumbered, it's tethered to, it's based on, it's at the cost of something else. And in this case, this evidentiary doctrine called fruit of the poisonous tree, which is an extension of the exclusionary rule, still under evidence and how it's admissible, is subject to 3 important exceptions. The evidence will not be excluded. It will not be excluded. When an evidence is excluded, it basically means it's not being used against you, hence the exclusionary rule. And one of the reasons why exclusionary rule would exist is if the evidence itself is tainted by a doctrine called fruit of the poisonous tree, which is the source and the means to how the evidence was obtained and everything else that's a derivative of that evidence that can be excluded as evidence against you, hence making it inadmissible. But it will not be excluded. In other words, it will be admitted so long as 3 things occur. And those three things are: one, if it was discovered from a source independent of the illegal activity, meaning it's an isolated source and it's not tethered to the illegal activity that can give rise to the derivatives of other things that could cause it to be considered fruit of the poisonous tree. And two, its discovery was inevitable, meaning if it was to work against you, whether or not they found it out legally or illegally, it would have been found out at the end of the day and would have still worked against you nonetheless. And three, or if there is attenuation between the illegal activity and the discovery of the evidence. Attenuation is just a fancy word that says something is losing significance over time. Something is losing energy gradually over time. Something is becoming weak. Something becoming less. In other words, the third exception is that if the connection between the illegal activity and the discovery of the evidence is weak, meaning it's not strong enough to be considered an illegal means to which the evidence was obtained. That's basically what this third one means. And if we don't have strong and sufficient evidence to say that the connection of how the evidence was found or why it was illegal, and we can't say it's affirmative and it's somehow weak and you can't really prove that it's illegal, then it's an exception. The second exception basically says that regardless of whether how they found the evidence against you was legal or illegal, it was inevitable to have come out one way or another anyway. In other words, the evidence that was once found illegally would have been proven or found legally. Then it can stand on its own and actually be proven to be legal in an inevitable manner. The first exception is that if it was discovered from a source independent of the legal activity, someone snitched on you, someone saw you, and that someone doesn't necessarily have to be a flesh and blood. It can just be one of those street cameras, right? It can be a satellite camera. You're private, right? But nonetheless, let's go into the details. And we'll simplify the details. Florida versus Royer, 460 US 491, year 1983. U.S. Supreme Court, case number 80-2146, decided March 23, 1983. This thing called fruit of the poisonous tree. If it's still not clear at this point, it is as simple as this. Justice White, joined by Justice Marshall, Justice Powell, and Justice Stevens, concluded that respondent was being illegally detained when he consented to the search of his luggage, and that such consent was tainted by the illegality and hence was ineffective to justify the search. This was a circumstance where someone was searched regarding some drug-related situations, but they had no reasonable articulable suspicion nor probable cause to search him. But nonetheless, they coerced them to verbally consent to it, and they eventually found some stuff on him. Despite this man or woman verbally consenting through coercion, they nonetheless had no probable cause to stop or detain that man or woman in the first instance. Therefore, the fact that he consented to it was a fruit of the poisonous tree of lack of probable cause. Hence, such consent was tainted by the illegality of the stop and search, and hence was ineffective to justify the search. It is that simple. It's not that complex. It's not spurious. But you will not get to the point of invoking this thing called the fruit of the poisonous tree doctrine if you don't know what Terry versus Ohio really says and the intricacies of why and how reasonable articulable suspicion can or cannot qualify as a substitution for probable cause or to probe for probable cause. Because this same case also speaks about Terry versus Ohio. A video of this was specifically done in the past at an earlier stages when it comes to probable cause. So go watch that to get a better comprehension of it, because that's the foundation to really being able to invoke this loophole that benefits you. This Terry versus Ohio is a loophole that benefits them. If you don't know their loophole, they can throw trajectories of curveballs at you, then you would not know how to then invoke your substantive right. Until next time, take care. Best of luck. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people, make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that our YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the Express Trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how, and the importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference and the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion, we show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight, beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things in nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.